Thank you, my ladies and my lords. We were just dealing with the issue of the suggested misdirection by the Court of Appeal, paragraph 24. This is to be found at MS 8. And I indicated that I was very much in favour of the interpretation being put on it by Lord Briggs.
Beware of Greeks bearing gifts.
Yes. Indeed. Appreciate
just so you know, what worries me slightly is whether it's actually right, in accordance with the history of how pain and suffering, loss and immunity damages have been calculated, to treat them as accruing over, to treat them as compensation for a wrong which is occurring over time, rather than something that's happened at a discrete moment in the past.
Yes, the point that I'm making is slightly different to that, and it's raised by the appellants as a ground of appeal. That's to be found at paragraph 2A, MS 45. And it's suggested that the Court of Appeal misdirected itself in relation to this point, suggesting that in that paragraph, that if a discount was made to the damages awarded now, it's likely the discount would be inappropriate in the relatively near future. But of course, the Court of Appeal are not saying that there will be convergence in the relatively near future. They're making the point that with the progression of income in St. Helena, which is progressing at a greater rate than that in the United Kingdom, if the discount factor were to be the appropriate measure, the measure will become out of date relatively quickly, as was shown by the comparison of Dr. MacLeod's reports, September 2016 and February 2017. There was a difference, albeit minor, between 3.16 and 2.97, but it's a progressing situation. And we submit that that's, first of all, it's a misunderstanding of what the Court of Appeal are saying, and secondly, it doesn't support a ground of appeal. In the case before the Chief Justice, the respondents could have asked for if the evidence warranted it, could have asked the Chief Justice to award damages greater than those indicated in the Judicial College guidelines. But the request was made to the Chief Justice for parity, because that seemed to be more appropriate. But we were all aware that Gibraltar had gone further than that and was trying to align itself with the Northern Ireland guidelines. A point has arisen on a separate issue about Rome 2 and a question directly from Briggs. And I think that potentially an error has been put forward to the court by the appellant, who was asked, in fairness, a question whilst addressing the court. The general principle under Rome 2, and this relates to the question that was put, if a claimant, an English claimant, and an English defendant were involved in an accident in India, what would be the law governing the damages that would be awarded? A general principle under Article 4 of Rome 2 is that the applicable law will be the law of the country in which damages occur, but there is an exception under Article 4.2 in common habitual residence, and therefore if both persons, claimant and defendant, share a common habitual residence, then the habitual residence is of the tortfeasor, not the location of the injury. So I'm grateful to Helena Jr. for providing that answer over lunch, and it's one in which the interveners agree with us. I've not had the opportunity of asking the appellants whether they accept that point.
So you say that the answer in that hypothetical question would be what? You apply English law and what, the Judicial College guidelines without
yes,
a discount?
and English damages, yes. In that particular instance, if both claimant and defendant were resident in England. And the context of the question was within the broader philosophical debate about whether or not the location of injury should, in fact, be determinative, or the determinative factor of the applicable law. We don't need to entertain such a difficult philosophical question in this case, because we're dealing with British citizens, and it is important, it is a very important factor, we submit, that they are British citizens with expectations to be treated as British citizens. But of course, in the earlier cases of Henry, 1996, and Lawrence, 1999, when the discount wages rule was applied, they were not British citizens. So dealing with the appeal, we submit it's wrong now to raise arguments which could and should have been raised at first instance before the Chief Justice, and could and should, in light of the case of Scott, have been raised before the Court of Appeal. But I've already made the point that the appeal document and the appeal itself worked on the basis that the wages rule was the correct approach. And this is an appeal court. So asking this court to remit the case back for some form of Bernal and Riley inquiry submit is not appropriate. So finally, I ask you to look at the case of Scott one more time. This is at Divider 17, and in particular paragraphs 23 onwards. The paragraph begins with, what is a reasonable sum? Must reflect local conditions and expectations. It must be taken against the background of the society in which the court...
Page reference.
I beg your pardon. MS 544, forgive me.
Of course, that was a case in which there had been a practice of providing an uplift.
The Bahamas case?
Yes.
Yes. But on this occasion, well, my submission is that we can use the words here, compare how the Court of Appeal in this case dealt with it, and we can simply transfer Bahamas to St. Helena, and we see the result. The Court of Appeal in this case followed closely the guidance given in this Scott case. And we know that local conditions are important. Lord Carr, in this case, indicated the decisions of the courts in Hong Kong, and I ask you to read paragraph 24, and in particular the reference to changes inevitably take place in everyday life of any growing society, and the expectations of the average person and family tend to increase as each year goes by. And then paragraph 25, the Bahamas must likewise be responsive to the enhanced expectations of its citizens as economic conditions, cultural values and societal standards in that country change. The guidelines may form part of the backdrop to the examination of how those changes can be accommodated, but they cannot of themselves provide the complete answer. They provide an insight. And then at the top of 545, the crucial point, and we submit the answer to this appeal, subject to that, local courts remain best placed to judge how changes in society can be properly catered for. And here we are dealing with an experienced Chief Justice who sits as in the Supreme Court, dealing with all family cases, civil cases and criminal cases. Someone who has years of service and knows the population better than anyone, I would submit, in this room. The the paragraph goes on to suggest if the guidelines are found to be consonant with the reasonable requirements and expectations of Bahamians, so be it. There shouldn't be a slavish following of the guidelines, and we submit that that's not the case. On the contrary, an award of damages on that basis, which happened to be in line with English guidelines, would do no more than reflect the alignment of the aspirations and demands of both countries at the time that awards were made for specific types of injury. And I've stressed at the time because that goes back to the point I made earlier, which suggests that there may be a convergence now between the awards that are applicable in the United Kingdom or England and Wales and St. Helena, but that may not always be the case. St. Helenians may feel in a decade's time or 2 decades' time that they should be aligned with Northern Ireland, or the government may feel, in fact, the conditions have not gone the way as expected, and there should be a move away from the convergence with the guidelines. This is not fixed. It applies at the time, and this is an appeal based upon the hearings or the cases the Court of Appeal dealt with in September 2017. I've already accepted paragraph 26. The cost of living indices are not the reliable means of comparing two jurisdictions. Incidents of tax, social benefits and health provisions, among others, would be relevant. Well, these were within the gift of the appellant in the Court of Appeal. They had this guidance from Lord Carr in the case of Scott, and there was no suggestion at that stage other than the wages rule. And forgive me for repeating a point, but at paragraph 28 there is the warning that the board should be reticent, properly reticent, about interfering with the Court of Appeal's assessment unless satisfied a wrong principle of law has been applied. And then, if I may, just to conclude, take you to the Court of Appeal's own decision, paragraph 24, MS 8. And 6 factors were taken into account in this one paragraph. Firstly, there was evidence before the Chief Justice that incomes were catching up on St. Helena with those in England and Wales. Secondly, the opening of the airport was likely to make that process continue and accelerate. Thirdly, a discount based upon a fluctuating measure such as wages would provide a potentially inappropriate level relatively quickly. Fourthly, St. Helenians are now British citizens when they weren't, when Henry and Lawrence, those two cases were decided. Fifth, there will be an increase in movement between St. Helena and the UK, which will be reflected in the expectations of the inhabitants of St. Helena. And six, the Court of Appeal took into account the higher cost of living on St. Helena. So, my ladies and my lords, we would urge the board to advise Her Majesty that the appeal should be dismissed for those reasons. Unless you have any questions about our submissions, those are our submissions.
No, thank you very much indeed, Mr. Williams.
Very grateful.
Ms. Corcoran?
I follow.
Sorry.
Gallagher.
My lords, I appear for the intervener in this appeal at the Equality and Human Rights Commission of St Helena, along with Ms Susie Allegre, who sits beside me today, and also Ms Fiona Murphy, who's not present today but has contributed very substantially to the written submissions. Our client, along with many others, is watching these proceedings via live stream in a courtroom in Jamestown. And let it not be forgotten that this is an appeal of the utmost importance to my client and many others who are watching live and who are watching against a backdrop of having seen coverage over the weekend from South Atlantic media services which summarised this appeal as relating to the following issue. The headline was, St Helena government arguing saints worth 1/3 of someone on the UK. So this appeal is of particular importance for the individual respondents, but it also raises very important issues for my client and for others. Now we have in the papers before you quite detailed written submissions which commence at MS page 592. Now we stand by everything that's in those written submissions. We hope you'll find it helpful. But today, given the limited time, I intend to focus on a few particular points. So I intend, first of all, to make some initial observations about how this appeal has come before the board and some unsatisfactory features of the submissions which have been made by the appellant today. And then second, I'm going to turn to 3 core points which we wish to advance orally. First of all, we're going to make some brief points about the legal and factual context in St Helena, with a particular focus on the 2005 ordinance, which of course also postdates those 2 cases from the 1990s, of which you've heard from both parties so far. Secondly, I'm going to address the issue of local expectations in identifying what is fair, reasonable and just compensation. And our submission in summary under this head will be that the courts in St Helena are best placed to consider whether to apply the Judicial College guidelines, if so, how to apply them, in light of local expectations, including the current expectations of St Helenians with regard to damages, and there's no proper basis for interfering with their decision on appeal. We will submit that the judgments of the lower courts show a careful and nuanced consideration of the changing expectations and conditions in St Helena such that a discount to the JC guidelines would no longer be appropriate. And critically for our client, we wish to emphasise that the phrase local circumstances in the 2005 ordinance, to which I'll take you in a moment, has been wrongly conflated by the appellant in his case with financial circumstances, and in particular, average local earnings in St Helena based upon a single snapshot of earnings as they stand currently, and with a number of other concerns which the Chief Justice accepted were problematic in the calculation. But in our submission, local circumstances is far broader, not only including a far wider range of financial factors, including the relative isolation of St Helena, travel costs, the high cost of living, and we endorse everything the respondent has said on those points, but also critically non-financial factors, including St Helena's special relationship with the UK and citizenship as part of that process, and St Helena's status as a non-self-governing territory for the purposes of the UN Charter. And then thirdly, I'm going to deal briefly with the fairness or balance point. And rather like my learned friend for the respondent, this was at the core of the submissions which we made to you in writing, but it's slightly shape-shifted, if I can put it that way, in how it's been put today before the court. So we'll address it as best we can in the format that it's been presented to you this morning. So firstly, the unsatisfactory way in which this appeal has come to the board. We've been told today that the Attorney General seeks the opportunity to argue the issues before the local courts and you've been told in terms that this is the only practical vehicle by which this can be achieved, this particular Privy Council appeal involving these particular 3 respondents who've suffered so horrendously. And we make 3 points. Firstly, the wide-ranging root and branch review suggested this morning, coming as a great surprise to many of us, it is not a process which can only practically be achieved through a Privy Council appeal. Indeed, there have been no submissions made to explain why the judiciary in St Helena is the appropriate body to conduct that review. Now, there was a question earlier about whether there's a law commission in St Helena. The short answer is no, there's no law commission, but there have on occasions been ad hoc commissions dealing with particular matters. So, for example, my client, the Equality and Human Rights Commission, was established following an FCO and DFID-funded Commonwealth Foundation review on human rights capacity in the British Overseas Territories and funded national human rights action plans. So there was an ad hoc investigation concerning human rights capacity in the British Overseas Territories, and it resulted in the formation of my client. There also was a number of years ago a commission on citizenship, as I understand it, from taking instructions over lunch. In fact, that was instigated by the bishop in St Helena. That's another example. And of course, it's perfectly within the gift. Of course, thank you. Not usually told I'm too quiet. Thank you. It's perfectly within the gift of the St Helena government, or indeed the FCO or DFID, to institute a form of commission on an ad hoc basis, if appropriate. And we have seen nothing in the papers before us to suggest that any of those routes have been explored. And it is particularly surprising to appear before you today during the hearing and to have this on the hoof suggestion that this wide-ranging root and branch review should be conducted by the judiciary through the mechanism of a form of relief which doesn't appear in the papers. We assume the form of relief they're seeking is a remittance to the local courts with guidance from the Privy Council as to what the review should entail. That seems to us very surprising. And we also say, of course, that it's quite plainly not a practical vehicle for these particular individuals who've had their compensation delayed for a period of well over 2 years, and who may well consider today's apology to be too little, too late, and indeed contradicted by the actions of the appellant in court today.
Can I just check, is there a legislature in St.
Yes, there is. I have taken instructions on the position of the legislature over lunch in light of the submissions that were made. I'm quite happy to put that to the board if appropriate. I thought it was not appropriate in circumstances where this has just been raised today and this is a second stage appeal. But I do have an indication of the position of the Legislative Council on this issue.
So can I just check, is it a local representative council?
Yes, my understanding is yes, it is. If you just give me a moment. Yes, I'm told given the size of St Helena, it's an elected legislative council. So we don't accept that this is the only practical vehicle. The second point is the reasons which were advanced this morning as to why these arguments were not made earlier, and there were 3 of them, we say don't stand up to scrutiny. It's just turning to my note. The first reason given was there are 2 existing cases in St Helena, the ones behind tabs 8 and 11, the personal injury cases from 1996 and 1999. And in our submission, whilst that may be, and we don't even accept that it is, whilst that may be a reason for this issue not to have been tackled head-on at first instance, simply does not stand up to scrutiny as to why the arguments were not dealt with in the Court of Appeal, in circumstances where the first instance decision had been that the prior applied discount was not appropriate. And of course these points could and should have been taken before the Court of Appeal. And for the Attorney General to now say we're seeking the opportunity to argue these issues before the local courts does not grapple with why the Attorney General failed to argue those issues before the local courts in 2017. And another matter which postdates those two cases is, of course, the 2005 ordinance. So we say that simply doesn't explain why these arguments were not made in the Court of Appeal. The second reason given related to the fact that in February 2017, the Chief Justice did not have the guidance of the board in the Scott case, dates from May 2017. And of course, that doesn't deal at all with why this wasn't addressed before the Court of Appeal, September 2017. And the third point was that the Chief Justice was somewhat led astray by some of the arguments, and you were taken to some specific points in the respondents' arguments below. Again, it was very focused on the Chief Justice, as if this is a first instance appeal in the Court of Appeal in St. Helena. And there's no reason, when you run through that material, which explains why these arguments were not advanced before the Court of Appeal. And it then leads us to some very unsatisfactory types of arguments, where, for example, you were taken selectively to some of the material relating to statistics. You've then had a response in relation to some of that material, which puts it in context and shows you many of the difficulties with the submission which is being made. And there's many more. I mean, throughout those submissions, I was constantly receiving from my client, from the messenger and from my junior counsel, many more difficulties with the material. This is not an appropriate way to deal with a second stage appeal. And the third point is the core argument on fairness and on balance has been put today in a way which I confess we find a little difficult. So we're told it's not the character of the tortfeasor per se, it's a broad economy model basis. It needs to be an objective assessment for the economy, not individual defendants. And we suggest, in line with the comment made by Lady Hale, that indeed the conflation between the focus on individual defendants and the economy is indeed a revealing error. But also, more fundamentally, we really very much struggle to understand the argument which was being made for the first time today, which is quite different to the arguments made in writing. So that's the first matter, and that all goes to why, in our submission, in addition to the usual reticence that you should have in any second stage appeal involving difficult issues which have been considered carefully at local level, there are additional reasons why the way in which this appeal has come to the board and has been argued before the board should make you all the more reticent to interfere with the decisions below. Now, turning to our points, I wanted to deal first of all just with some very brief points of context. Now, we dealt in our written submissions in some detail with the constitutional and legal context in St. Helena, and I won't take you to all of those points, but may I just give you the reference for your note. It starts in our written submissions at MS page 594, and it's section 2. But I want to highlight two key points already today. The first one can probably best be taken by turning up a document in the intervener's materials at MS page 625. So it's in the intervener's authorities, and it's tab 20. So it starts at MS page 622. Does everyone have that?
It's the Foreign and Commonwealth Office document on overseas territories.
That's it, my lady. So at page 625, if you look over on the right, it says the UK government's fundamental responsibility and objective is to ensure the security and good governance of the territories and their peoples. This responsibility flows from international law, including the Charter of the United Nations. It also flows from our shared history and political commitment to the well-being of all British nationals. This requires us, amongst other things, to promote the political, economic, social and educational advancement of the people of the territories, to ensure their just treatment and their protection against abuses, and to develop self-government and free political institutions in the territories. The reasonable assistance needs of the territories are a first call on the UK's international development budget. And that's a relatively pithy summary of the points we're making in our section 2, which is that St. Helena, as an overseas territory, has a distinct and special relationship between Ireland and the UK. And that's reflected in the UK's laws concerning overseas territories. It's reflected in international standards, and it's also reflected in laws specific to St Helena. And the recognition in this document, the 2012 White Paper, is that the reasonable assistance needs of the territories are a first call in the UK's international development budget. That's quite important when you turn to what sounded like quite a simple throwaway line, common sense, in the submissions by the appellant this morning. Because the appellant this morning said, money spent on one thing cannot be spent on another thing, as if it was simple, that if you take something from one aspect of the public purse, it can't go somewhere else. But I'm afraid it's much more complicated than that when you're looking at an overseas territory, and when you're looking at an overseas territory in which the European Convention on Human Rights applies, as do many other international instruments, all detailed in our written submissions. And if there is a need for compensation to be paid to an individual, such as any of these respondents, there is potentially an alternative source, given the obligation upon the UK to ensure that the reasonable assistance needs of the territories are met. And similarly, when the reference was made very early on in the appellant's submissions to how, on the face of it, I'm quoting, it might be surprising that what is considered appropriate in the developed economies of England and Wales would apply in this island, a new reference was made to it being remote, a volcanic rock, and the small size of the population. That doesn't tell the real picture when you're dealing with one of the very small number of the overseas territories. Right it is that the overseas territories have got a very small population, and many of you will know from the Dixon and Hendry text, which incidentally, as I understand it, was written on the deck of the Royal Mail ship, the St Helena, at that time being the only means of access to St Helena prior to the airport, and you see that in its preface. There are only 14 British overseas territories. Their combined population is slightly less than that of Norwich. So if you look at population alone, you do see that it's small. If you look at location, you of course see that it's remote. But that is not a fair characterisation, and indeed, as I understand it, many of those watching in Jamestown found it quite a belittling summary this morning of their status and their role as British nationals. Now, the second point which flows from this is the 2005 ordinance, and you have that also in the intervener's papers at the start of our authorities. So you find that just before the document that you've been to, the FCO document, it's tab 19, and it starts on MS page 611. And this ordinance provides for the application of adopted English law to St Helena. Key provision for you to look at is section 2 and section 3. So section 2 is on MS page 612. Adopted English law. In this ordinance, adopted English law means the common law of England, including the rules of equity. And of course, as we know from other materials, I won't take you to all the references, the judicial guidelines, judicial college guidelines are derived from the common law. And when you look at section 3, it provides in 2005, a decade after that case that you were looking at from 1996, 6 years after the 1999 case, subject to subsection 2 and other provisions of this ordinance, the adopted English law applies in St Helena. And it then says in section 3.2, the adopted English law applies to St Helena only insofar as it's applicable and suitable to local circumstances, subject to such modifications, adaptations, qualifications, and exceptions as local circumstances render necessary. So it's quite different. The analogy you had earlier with the motorcycle accident in India doesn't really take you very far when you're dealing with an overseas territory, and when you're dealing with an overseas territory which has in place this ordinance from 2005, and when you're dealing with individuals who are British nationals. And we've dealt with that in quite some detail in our written submissions. So the context is very different, and we would be careful with some of the analogies which were used this morning because they simply don't reflect the context here. And that context is picked up. If you look at Lord Kerr, I'll just turn you to this particular paragraph which may be helpful. It's MS page 544. So this is Scott and the Attorney General of the Bahamas. It starts at MS 537. I just wanted to draw your attention to paragraph 25. So paragraph 25, referring to the Bahamas, it says the Bahamas must likewise be responsive to the enhanced expectations of its citizens as economic conditions, cultural values and societal standards in that country change. Guidelines from England may form part of the backdrop to the examination of how those changes can be accommodated, but they cannot of themselves provide the complete answer. And that's
Well, we've just looked at that.
Of course. That's very much in keeping with the phrase which we've picked up in our written submissions about them being guidelines, not tramlines. The reason I draw it to your attention is the reference there to economic conditions, cultural values and societal standards is, as both we and the respondents say, critical when you turn to local expectations in identifying fair, reasonable and just compensation. So in our submission, the appellant's case is focused almost exclusively upon the issue of wages and is certainly focused exclusively upon financial factors as being the key relevant local conditions. They refer in their written submissions to economic factors such as average earnings, cost of living, the availability and cost of insurance. You see that at their paragraph 15. With this particular focus on current average earnings in St. Helena based upon a specific temporal snapshot only. And similarly today, when dealing with the new fairness point, it was very much focused on the economy. And in our submission, that fails to recognise the relevance of non-economic factors, cultural values, and the very particular constitutional, legal and historic context of St. Helena. They are factors which may properly be taken into account by the local judiciary, and they were appropriately considered and taken into account at paragraphs 24 to 25 of the judgment in particular. And the judgment itself, on which we haven't spent a huge amount of time today, deals in our submission in some detail, paragraph 6 to paragraph 25. That's where the analysis is on this issue. And in our submission, those paragraphs involve a careful, nuanced and wide-ranging analysis of the case law, resulting in a conclusion that they agreed with the Chief Justice in the result but not the reasoning. And very little has been said to you to try to pick apart that reasoning. There's been some focus on a particular sentence in paragraph 24, but nowhere do we find an argument from the appellant which strikes at the heart of the reasoning in paragraph 6 to 25. And in our submission, paragraph 6 to 25 fit entirely with the submissions made by the Commission. They reflect the fact that the 2005 ordinance provides for the application of adopted English law to St. Helena only insofar as it's applicable and suitable to local circumstances, enshrining that principle in the Scott case. They reflect the fact that the Court of Appeal was careful to look at financial factors, not based solely on a single temporal snapshot of wages, but also looking at the context in relation to wages and trends. And you see that from paragraph 24. And my learned friend for the respondents has given valuable and, in our submission, very important context to those findings which are summarised in paragraph 24. And another key point for my client relates to the fact that the statistical material involved the exclusion of the income of technical cooperation officers because they work based on international pay scales. It sounds like a small point, but it's an important one. I'll just give you the references rather than turning it up. It's MS page 188 and MS page 197. It's a rather circular argument that although these are individuals who are living and working in St. Helena, because their pay is based on international pay scales equivalent to the UK, they were being carved out. So the figures that you get are artificially low because of their exclusion. And again, that's not an exclusion which we consider appropriate. It wasn't an exclusion which the Chief Justice considered appropriate. And then in summary, we get to the first stage of appeal, the Court of Appeal considered that there was force in some of the criticisms of the material below.
So they are the TC officers, are they?
Yes, that's right.
And what does TC stand for? Sorry.
So it's Technical Cooperation Officers. I think, although it comes second in time, MS page 197 is a little better at giving the detail, and then MS 188 gives you some more of the material.
Thank you.
Of course, the exercise of applying the JC guidelines is reliant on judgment and experience applied to the circumstances of the case. And judicial experience includes local experience, as Sir John Saunders in the Court of Appeal in these cases made clear at paragraph 23. And the test is what the particular society would deem to be a fair, reasonable and just sum, such as it would allow the wrongdoer to hold his head amongst his neighbours and say with their approval that he's done the fair thing, that quote from Weston Shepherd. And in our submission, the analysis on this issue is paragraphs 22 to 25 of the Court of Appeal's judgment, and it's unimpeachable. Sir John Saunders cites the Scott case and the analysis of Lord Kerr, describes the test appropriately, and correctly summarises the position. He makes clear that the Privy Council didn't approve in that case the automatic use of the guidelines with a fixed uplift or discount. It left a considerable amount of discretion to local judges to arrive at an assessment which was fair in that it reflected local circumstances. And that's the backdrop behind which he then, in paragraphs 24 and 25, reaches the conclusion that he does, indeed that the Court of Appeal as a whole does. So this is a unanimous judgment of the Court of Appeal, making clear that the approach in Scott must also apply to St Helena, allowing considerable discretion to local judges. They find unanimously that they're satisfied that the level of damages should remain tied to the JC guidelines, and in light of all the evidence given before the Chief Justice, that it's not appropriate to apply a discount, as that would not properly reflect the conditions in St Helena or the present expectations of its inhabitants. And those two paragraphs summarise a number of the key aspects of that evidence, paragraphs 24 and 25, including both financial aspects and non-financial aspects.
Ms Gallagher, I must warn you, you've only got 1 more minute.
Yes.
Well, sorry, 3 more minutes.
3 more minutes. Yes, my timing was, I thought I had slightly more. I'll take my 3 minutes. So in terms of financial aspects, our core focus is that there's a distorted calculus which has been applied here by the appellant, focusing on the single factor, current average earnings in St Helena above all others, and in circumstances where the calculation itself is problematic. And in our submission, that's contrary to principle, entirely selective, not appropriate. And then in relation to non-financial aspects, the broader aspects, it was quite right that that was taken into account by the local court, familiar with local conditions. They were quite right to take account of the hopes, aspirations and expectations of St Helenians. And their expectations include, critically, being treated in like manner to their fellow citizens in England and Wales. Now, it's quite wrong to argue, as is done by the appellant in his written case, at paragraph 4, that this involves the court mistakenly equating citizenship rights with an entitlement to a specific level of compensation for personal injury. It's a much more nuanced point. The Court of Appeal was quite right to take account of this as a material factor when considering local conditions in accordance with the 2005 ordinance. And it's clear from those paragraphs 24 and 25, that's precisely what it was doing, taking into account the present expectations of the people of St Helena in light of their now being British citizens since the significant change in 2002, and in particular their expectation of quality of treatment. And that's a key factor and it was rightly taken into account. Now, the final point I want to turn to relates to the issue on fairness. Now, as we understood this point from the written materials, we understood the argument to be that a downward adjustment should be applied to a sum assessed to be fair, reasonable and just compensation in order to strike a balance with the tortfeasor's ability to pay, whether by reference to local earnings or otherwise. And what we've received today is a little different. What we've been told today is it's not related to the tortfeasor's ability to pay, it's a reference to the overall economy. It's an overall economy model. And I'm afraid my client finds it very difficult to answer a point which has only been advanced today in this very vague way. And in our submission, a broad economy model basis for downward adjustment of a sum which is otherwise considered appropriate is not persuasive in itself, but also simply not a basis for this board to find that there was an error of law by the Court of Appeal in paragraph 6 to 25 of a very nuanced, careful judgment in circumstances where the point was not before them. And frankly, it's not properly before us because it hasn't been articulated and developed in a way which we can even really engage with. And we would be extremely surprised if a broad economy model basis with, using the phrase, an objective assessment for the economy, not the individual defendants, could possibly be considered an appropriate mechanism to use, rather than the approach taken by the Court of Appeal so carefully in its detailed judgment. Could you give me a moment? Nothing further. If there's anything we can assist with in particular, factual issues in St. Helena, my client's very happy to oblige. And if you do need more information on those particular ad hoc commissions that we took instructions on over lunch, we're happy to provide that in writing if that would be of assistance.
Well, thank you very much. We're very grateful to you.
Thank you.
Thank you.
May it please you, my ladies, my lords, may I rescue the... Thank you. Erudite but robust was how I had described to myself the submissions of the intervener. Not as robust as the oral submissions, and there are some errors, I'm afraid, that I need to correct.
There's obviously very considerable needle locally about this.
Yes.
But I speak entirely for myself.
Yes.
Whatever the result of the case, nobody could reasonably have taken objection to what you said this morning.
Thank you very much. I'm very grateful, my lord. I'm really most grateful for that because I did feel a little under attack at times, has to be said. But the first thing I want to deal with is actually the most important in many ways because it's the most important to these two plaintiffs, or three plaintiffs, but the two women in particular. My learned friend, Mr. Willems, said that the apology was waited some time and too little too late was what the intervener said. Well, I'm very sorry to have to correct them, and the intervener should know this because the intervener's instructed by the deputy for one of the plaintiffs. I'll just give the board the reference. It is MS page 89, paragraph 5, in the opening skeleton argument for the attorney at trial, where a fulsome apology was given in writing. Mr. Willems will know because the Attorney General was required to give evidence, and Mr. Willems asked him specifically about the apology, and of course he apologised in the witness box. So I'm sorry to have to do that, but nevertheless it is important in the light of what I've said. Mr. Willems repeatedly used the word concession about the way we've put it, and Ms. Gallagher complained bitterly about the point having only been made today about the broad economic model. Clearly that's my fault in the written submissions not having been sufficiently carefully described. Perhaps sometimes in the interest of brevity I maybe cut some things out. But if one reads the submissions, in particular paragraphs 6 to 8, it is quite clear that we have never taken the point that you look at the individual tortfeasor to see whether they're insured, what their means are, and so on. Our case has always been that it is broad circumstances. And, my lady, it's MS page 235, no need to turn it up, but we specifically say reasonable compensatory award must reflect local conditions and expectations. That are taken directly from Scott. And at paragraph 6, we refer to the equitable balance between fairness to the recipient and fairness to the paying party. But that's exactly where I started in Scott, which is that damages must be fair for the claimant to receive and fair for the defendant to be required to pay. And that's no more, no less than we have always submitted. So, my lady, I'm conscious of time, and we have been through a number of paragraphs, but there are some paragraph references in Highland Rankin. I'll just give the reference because we've already looked at them. But Mr. Willems suggested that nowhere does it say in the cases, and in particular Highland Rankin, that the defendant should be considered. But actually at paragraph 27, what the Court of Appeal said, quote, is that the level must not result in injustice to the defendant. He suggested that Lord Wolfe chose the incorrect word when he was talking about proportionate in paragraph 36 to describe damages, and that reasonable would have been appropriate. But in my submission, the two are synonymous in the context of an award of general damages. And proportionate refers to what I have described in paragraph 6 of our written case as a proportionate, as an equitable balancing award. If damages are to be fair for the defendant to be required to pay, then one must engage in some kind of equitable assessment, not disregarding the paying party altogether. And that's really the nub of our submission, and has always been the nub of our submissions. It was suggested by Mr. Willems that I had conceded that there was no basis or justification for the arbitrary rule in Henry and Lawrence, the two cases where the wages rule, as was described, was applied. That actually isn't what I said. What I actually said was that there was no reason justification given by the judge in those cases. Now, it is true that in some jurisdictions and in some of the cases, and we've looked at some of the previous Privy Council decisions where they're referred to in the papers, where wages have been regarded as a proxy for an assessment of damages. So it's not that I'm conceding that they're irrelevant. On the contrary, I'm saying they are relevant, but they're one of the more relevant factors. My lady, a point was taken about the discount rate. This arose from the Gibraltar case. And one knows that in the discount rate, the lower the rate of return on money, the higher the awards of damages required in order to compensate someone for pecuniary loss. That was taken into account by Mr. Justice Jack in the Gibraltar case. It was referred to by Mr. Willems, who then immediately went on to describe damages for IVF being based on UK costs. Well, of course, damages for IVF would be pecuniary loss, and of course, they would also not be significantly affected by the discount rate because they're going to be time limited, unlike, say, care for the rest of life, which would be significantly affected and would be a lifetime.
I thought he was just referring to the way in which an appellant might choose to use the compensation for pain and suffering.
I didn't believe that to be his submission, because it would be a separate head of loss, would be the costs of IVF treatment in this country or in America or wherever else it was reasonable for the claimant to go. But the point that is of significance for the board in this case is that the discount rate change, although it was referred to by Mr. Justice Jack in the Gibraltar case, in Bernal and Sidney Reynolds, or is it Sidney Reynolds?
Riley.
Oh, anyway, I'll find the reference. But it was referred to by Mr. Justice Jack. But in the numerous changes to the discount rate that there have been over the years, there has never been a linked change to general damages. The Judicial College has produced new guidelines from time to time, but they have not been linked to the general damages, nor were they linked when the government has announced changes in the discount rate. So it is very much an indirect link. And in Highland Rankin, the court were much more influenced by life expectation changes, and in particular by increased life expectation in catastrophically injured claimants. And for the board's reference, it is MS, page 387, paragraph 92. my ladies, my lords, I too got some instructions over lunch. And in answer to the board's questions, I have some information. A point was taken about access to justice. I was told that, in fact, there are 4 public solicitors, 3 full-time, 1 part-time, supported by either 1 or more legal executives. I couldn't be clear, and the communication was very difficult. But in a population of 4,500 people, that's quite a significant proportion. In terms of the number of cases, the board asked a question about how many personal injury cases were there, and the answer is that the Crown Council is aware of at least 20 ongoing personal injury clinical negligence claims. Many of them are clinical negligence, and new Crown Counsel has been in the job for about 3.5 months, and she's had 6 new cases, mainly clinical negligence. So this case will have significant repercussions.
When you say Crown Counsel, these are ones involving the Crown?
Because they're clinical negligence and the hospital's
Yes.
run by the Crown, so yes. There plainly are likely to be others, but I have no source of information for others.
And presumably, as long as this case remains outstanding, they're pretty impossible to settle.
Yes. I'm not involved in any of them that I'm aware of, and so, but yes, exactly so. Mr. Williams relied upon the airport and suggested that it wasn't irrational to think that it was done for economic reasons, and referred to commercial flights having started in 2017. That is correct, but I'm told that in fact there's only 1 flight a week, and it's a much smaller plane than had been anticipated. It is in the public domain that there were well-publicised wind shear problems which led to the airport being delayed by over a year, and much smaller planes than had been anticipated being able to land. So, of course, this is 2017 when commercial flights started, so it wouldn't have been possible for the court to know how the modelling would work out. It's been suggested that a discount, and in particular because of a changing ratio between UK earnings and Saints' earnings, St Helenian residents and citizens being referred to as Saints, and it's been suggested that would make it impractical to settle cases. Our answer to that is it's easily done. So long as the court provides the indices which the parties need to have regard to, you simply look them up, as you do with RPI when increasing awards for inflation. We spend a great deal of our life when doing this work in tables and calculating figures. It is easy. All we need is the mechanism. So that will not be a bar to settlement, nor will it introduce uncertainty. I'm grateful for the correction on Rome 2, and I will check it. It's an extremely complex area of law, and I don't pretend to be an expert in it. But I was taking the reference, and for the board's notice, MS 275, Alceran case at paragraph 902. And that would be the ordinary Article 4 situation where in my Indian example, for example, there was a UK victim and an Indian driver, and then in that case the local law would apply. I take it from my learned friends, and I'm grateful for the correction, that if both tortfeasor and victim are non-resident in the jurisdiction, then I take that point. If, on checking it, it's appropriate for me to say anything further, then perhaps I could do so in writing as quickly as possible.
Thank you.
Would you accept that the departure from adopted English law to meet local conditions, which I think is prefaced by the words "where necessary to meet local conditions," in Section 4 of the 2005 Ordinance, may impose some sort of burden on the person asserting that there should be a departure to demonstrate that it's necessary?
That's a very interesting point which is raised in the intervener skeleton, that it suggested that there was a presumption in favour of application of the guidelines. It's actually section 3,
But I wasn't
subsection
jumping
2.
straight to a presumption in favour of the application of the guidelines, but that's the general concept.
Yes, it is. I'm not entirely sure what the answer is to that, my lord, I have to say, because general damages for the assessment for personal injury are known to be a difficult judicial exercise, and the best starting point is Judicial College guidelines. We all accept that. The question is whether the presumption or the burden is upon the person suggesting that they don't apply or they should be adjusted, has the burden of proving it. And probably ordinarily, if one's going to depart from broad guidance, then yes, that probably would be the case. Yeah. But whether it goes as far as a presumption, in the light of section 3.2,
I did put the question in form of a burden.
No, indeed, but I understand what it's related to. But there is clear provision in 3.2 for application of local circumstances. Dealing finally with Mr. Willem's submissions about British citizenship, which also touches upon what the points that the intervener made, the problem with references to citizenship, and I accept that broader circumstances than economic are relevant to the assessment, but the problem is that it risks falling into the fallacy that citizenship dictates the method of assessment. That's the fallacy we submit that the Court of Appeal fell into, and it clearly is the fallacy that the Chief Justice fell into. So if one considers citizenship and residence as broader, as part of a much broader picture, then I would accept that it is relevant. But our submission is that it led the court into error. We completely accept and agree that local courts are best placed to assess the damages. We've been there and I've dealt with that point. Save that, in my submission, as in Bernal and Samuel Riley, the court needs to have the evidence and the arguments and not simply to do it on the basis of either a misunderstood rule or incomplete evidence. It's not suggested on our part that there should be root and branch review and law commission assessment. What is suggested, it's a judicial assessment. And what we have suggested is that it should be returned to the court below so that they can review it in the light of evidence which relates to all of the factors that I have read, which they did not have below. And so that's our submission. We are not inviting the board to say that there ought to be a Law Commission report. The factors which are relevant have been identified in the Law Commission's report and in the case law. The question is how the judges then deal with what evidence there is that relates to that. And if my ladies and lords would give me a moment, that may be... Perhaps my lady would forgive my back for a moment. My ladies, my lords, I'm extremely grateful unless there's anything further we can assist with.
I think not. Thank you very much.
Obliged, my lady.
Everybody has been extremely helpful in this case. We do understand how sensitive it is for everybody involved, and we hope that those watching in St Helena understand the nature of the exercise that we're engaged in, which is obviously to consider the arguments that have been presented for us so fully and carefully by everybody on this appeal. The board will take time to consider what advice they will humbly tender to Her Majesty.
Very much obliged.